Uh, Welcome to those online who hopefully can now hear us. My name's Piers Verstegen. I'm the Director with the Conservation Council of Western Australia. And we're putting on this event in conjunction with the Environmental Defender's Office. And also thanks to the UWA Law School for allowing us to use their beautiful venue here. Can I acknowledge Alex Gardner, who'll be speaking, who's here with the UWA Law School, Tim Barling, who's our Vice President at the Conservation Council, and of course, can I acknowledge the Noongar Whadjuk traditional owners of this country where we meet, and acknowledge that this country was never ceded, sovereignty was never ceded for this country. And also just want to take the opportunity to acknowledge that there is a system of Indigenous law which survives to this day and which is survived by those who continue to practice it. And that's an important thing to bear in mind when we're talking about the law and the courts and the legal processes and all of those things that we're here gathering to talk about this evening. So we are here to talk about a different kind of law though. And judging by the audience this evening, there's a great appetite to have this conversation. And since we started advertising this event, there's been a bit of a buzz. So many people have been interested to hear what will be said and spoken about. And so, yeah, we hope that this will satisfy your interest. I think we all know why we're here and why this issue is perhaps so pressing. Western Australia's carbon pollution continues to rise at a time when we're already living with the dire consequences of climate change. As our homes and wildlife burn in wildfires, as our farmers experience record drought, as our reefs bleach, and our wildlife is pushed closer to the brink of extinction, literally as these things are happening, our governments and the fossil fuel industry here in Western Australia are planning the most polluting projects ever proposed in Australia right here on our doorstep. What's happening in Western Australia here is an extreme example, but it's by no means the only example of this around the world. Our governments and industry paying lip service to climate change, even making commitments to things like the Paris Agreement and net zero emissions, while at the same time using those commitments and policies as cover to continue polluting and increasing pollution. This isn't just business as usual that we're grappling with. In some cases, it's worse than that. And I'm sure I don't need to remind you of the appalling spectacle we saw here in 2019 when Premier Mark McGowan was called into a crisis meeting with the heads of the WA gas industry amidst a campaign run by the West Australian and Woodside against the EPA. The Premier then proceeded to instruct the EPA to withdraw their science-based policy on climate change in favour of a compromise that would allow pollution and fossil fuel profits to continue increasing. And so here we have the fossil fuel industry literally dictating policy on climate change to the government and the EPA. And I need not remind you of the proposed Woodside Burrup Hub development in our state's northwest, which is very connected with these events, of course. We previously estimated that the combined carbon pollution from this development would be roughly 4 times as great as the Adani coal mine, making it the most polluting project ever proposed in Australia's history. What you may not know, because there's been no public process or consultation, is that the first major parts of that development have already been granted approvals with no environmental assessment of the pollution it would cause or its consequences for the climate. We argue these decisions were made in breach of the law. And that is why the Conservation Council, with the assistance of the EDO, have commenced a legal challenge to those decisions in the Supreme Court of Western Australia. We'd be derelict in our duties if we didn't do that. That case illustrates the importance of climate change litigation, but we're not here to talk about that specific case. Instead, we're here to talk about the many other ways that we can potentially engage the courts and the justice system here in WA to defend our collective and individual rights to a safe climate. Now, many of us, the whole idea of the court system and the justice system seems quite foreign. There's a whole language around how the courts operate, how the judicial system operates, that many of us find very unfamiliar and probably quite intimidating. For most of us, the closest that we've come to the justice system might be an unpaid speeding fine, or perhaps for some in the room, it's appearing before a local magistrate after being arrested for some kind of protest action. So unless you're a lawyer or some other learned practitioner in the law, the courts might seem a bit mysterious and quite adversarial. Certainly not somewhere you would voluntarily want to venture. And these systems don't tend to spring to mind as a way to resolve complex environmental, social, economic, and political issues like climate change. But the judicial system is our system. It's there to be used to defend our rights. But we can't expect that judges in the courts will act by themselves unilaterally, because that's not how the judicial system works. The system itself relies on people like us and organisations like ours to do the work to bring these matters before the courts where they can then be considered and resolved. And so in a state and in a place where other democratic and political avenues that we have available to defend our rights and our climate seem so badly malfunctioning, we individually and collectively have a responsibility not to be intimidated by the legal system and instead find constructive ways to engage with it. If the legal system does present opportunities to advance or resolve these intractable issues, then as citizens, we have a responsibility to identify them and pursue them. And that's exactly why we've put the event together this evening, because at the Conservation Council, we feel that responsibility very deeply. But at the same time, we know it's a collective responsibility. And it's a responsibility that we must all share. So our event this evening is designed to help break down some of those barriers that I've spoken about, to help us better understand some of the ways the judicial system may be used, and to defend our rights and our climate, where governments refuse or are incapable of doing so. We know that climate change litigation in its various forms is becoming a much more common tool for communities and organisations around the world to defend a safe climate. And there's been some high-profile wins around the world against various governments and companies. Here in Australia, we've already seen a number of cases challenging coal mining projects on the East Coast. And I was involved in some of the first legal challenges against the Adani coal mine proposal when I was Vice President of the Australian Conservation Foundation. Those cases have helped pave the way for our current case here before the Supreme Court challenging the Burrup Hub, which is probably the first example of climate change litigation here in Western Australia. But challenging environmental approvals is only one example of the type of legal proceedings that can be brought in defence of our climate. There are many other areas of law that can potentially be accessed for this purpose. But the difficulty is that a case that might work in one place or in one type of court might not work in another. It may be that the law is constructed differently. It may be that evidence in one place is not admissible in another. It may be that in some places people have legal standing to bring matters before the court, and in other places they don't. So, and there's a whole lot of other questions around these sorts of issues. And that's why we've engaged the experts at the Environmental Defender's Office to undertake a thorough investigation of the different modes and the different models and methods of climate change litigation and how they might be applied here in Western Australia. And so the event tonight is really exciting to us because it's really the result and the culmination of that investigation, which has been led by Sarah Flynn who I'll introduce shortly. But I just want to make one final point before I do that, which is to highlight that many of the legal avenues that Sarah and the EDO team have identified are not necessarily available to organisations such as the Conservation Council. They may rely on arguments brought by individuals, by landholders, by shareholders, by farmers, by traditional owners, or a whole range of other parties that we may not have even thought about who may be affected directly or indirectly by climate change. And in that sense, we hope this event and this information that will be presented can help provide some hope for all of us by shining a light on some of the opportunities that we perhaps haven't even been aware of. We hope you'll go away from this event feeling hopeful and empowered that you and together we can exercise our rights in a way that can protect our climate and our future. So with those introductory comments, I'll now introduce our speakers, and there's going to be 3 of them. And then after that, we'll go to a panel discussion where we'll have time for question and answer. As I mentioned before, Sarah Flynn has led this work for the EDO. So it's my pleasure to introduce Sarah. Sarah completed her practical legal training at the EDO in WA in 2017 and commenced as a solicitor in June 2018. Sarah's work includes providing advice and representation on a range of environmental issues, with a focus on climate change, and also gas fracking has been a big issue that Sarah has looked at, as well as drafting a lot of law reform submissions. We also have Ruby Hamilton joining us. Ruby may be a familiar face to some of you who've been attending Environment Matters events. We had the session last month on the Burrup Hub Legal Challenge, which Ruby has been working on. Ruby's been at the EDO since being a law graduate and was admitted to practice in December 2018. Ruby's work as a solicitor at the EDO has comprised of advice and representation on a broad range of matters, including litigation and merits appeals on environmental issues in WA, such as uranium mining, forestry, and greenhouse gas emissions. And of course, Ruby also and Sarah both also worked on the Yeelirrie legal challenge to the Yeelirrie uranium mine. And we also have with us Alex Gardner, Professor Alex Gardner, who currently works at the University of Western Australia, where he's been based since 1988 as a professor of law, and as a professor of law since 2015. Alex is certainly part of the alumni, if you like, of the Environmental Defenders Office, having been a past convener of the EDO here in Western Australia. And besides his teaching and research interests, Alex has since 1994 been an environmental legal consultant, especially to the EDO and to the Western Australian government agencies responsible for water resource management in particular. So we've got a real wealth of and depth of knowledge here with us this evening. And I'm sure that you'll agree that these expertise are brought to bear on this issue in a way that can inspire us all. So I think now I'll just hand over to Sarah, who'll take over and provide us a presentation, and she can introduce the others to help her present this huge body of work where necessary. So thanks, Sarah, for joining us.
Just to start off, to tell you all a bit about the Environmental Defenders Office, we are a legal centre that is dedicated to protecting our climate, communities and shared environment by providing access to justice, running groundbreaking litigation and leading law reform advocacy. So today I'm going to talk a bit about climate change litigation trends and opportunities here in WA. I'll start off by providing a bit of background about climate litigation trends both here in Australia, but also across the world. I'll then provide a bit of WA context and why our opportunities are a bit more limited, unfortunately, but also some opportunities available too. I'll then move into the traditional opportunities for climate litigation that we've already been pursuing, which is judicial review. which Ruby will help me present about. And then I'll move on to novel opportunities for climate litigation, which include corporations and consumer law and tort law. I'll then conclude a bit about what are your climate rights after going through some quite complex legal opportunities, and hopefully I'll be able to make them digestible to the general audience. So starting off with a bit of background, so I'm sure we're all aware that a lot has been happening in the climate litigation space across the world. Climate litigation is broadly defined, so it includes legal action which seeks to address the causes or likely impacts of climate change. So it's quite broad. So this can encompass both cases that have climate change as its primary focus, but also cases that have climate change as a more peripheral issue. While it's not the focus, it comes up as a more side issue. So there's a big trend of climate litigation all over the world. There's been over 1,500 cases filed across the world. And there's been an emergence of next generation or novel climate litigation lately, which is based on creative and innovative legal arguments. It may surprise you to know that Australia actually has one of the highest rates of climate litigation in the world. However, these are based on more traditional arguments using judicial review and merits review. So that kind of goes towards those cases that have climate change more as a side and peripheral issue. So it might not seem like it is climate litigation, but it actually is. So here in WA, as I mentioned, we are relatively limited. Unfortunately, we do not have a specialist environment court here in WA that can deal with merits review appeals. So I'm sure you're aware of some courts in other states, so the New South Wales Land and Environment Court. Those courts can deal with merits review appeals. And so merits review is where a decision is reviewed on the basis of its merits, which is whether or not the decision was the correct or preferable decision. However, because we don't have a lot of avenues for that here in WA, we are limited to judicial review, which is a lot more restrictive and requires a legal error in decision making. Ruby will talk more about that. We also do not have federal or state human rights legislation. So what I meant to mention with the litigation trend over the world, there's a range of different types of cases that have been brought, and I'm sure you would have heard some of these. So there's some cases brought on the basis of human rights. There's some based on constitutional rights, some based on tort law, some based on corporations law, and also in the US on a breach of the public trust doctrine. Here in WA, we don't have any real opportunities to make arguments on the basis of human rights because we don't have state or federal legislation. And while we are subject to international law, that doesn't have a lot of power in the courts unless it is expressed in legislation that applies at the state or federal level. This is unfortunate because the Queensland Human Rights Act, which was brought into force in 2019, has had a lot of success, and the first human rights case here in Australia was brought as a result of that legislation coming into force. We also do not have any constitutional rights or duties that apply here in WA that might relate to climate change. So, for example, the right to a healthy and clean environment. We also don't have the right to life. So our constitution does have various rights that are expressed and implied. However, they don't go as far as to incorporate those rights that might be used in climate litigation like it has across the world. So starting off with the traditional opportunities for climate litigation here in WA, Ruby's going to talk through some judicial review opportunities.
Thanks, Sarah. Oh, I haven't even done anything yet. Okay, well, thanks for that, Sarah. So my name's Ruby, and I'm also a solicitor at the EDO, and I've kind of been involved so far in a little bit of the sort of traditional climate litigation, which is judicial review. I'll talk a little bit about judicial review opportunities and take you through a case study of something that's actually before the courts at the moment, which will probably bore people who went to the last Environment Matters, but I'm sure there are some people still interested. So in terms of climate litigation in judicial review, environmental decision-making under statutes can be challenged for errors of law. So that's what's called judicial review, that sort of challenge. In terms of a climate right, you can kind of think of this as the right of citizens to hold governments to account for unlawful decision-making. So there must be a statute for this decision. So there's our little Environmental Protection Act, and that's what most of our climate judicial review type cases are going to come from. So decisions that are made under that statute or powers that statute confers on a government decision maker. And certain terms on which that power is going to be available to them. So then if they make an error of law in the pursuit of exercising that power, this is distinct from an error of fact or an error in the merits of the decision, as Sarah outlined earlier. So errors of law mainly depend on the processes that the decision maker goes through in exercising a power before they can exercise that power. So that's what we'll get to talk about before the Supreme Court. They don't want to hear about the merits of decisions and those sorts of things. So these cases tend to have sort of more incidental or practical climate relevance. They're about the legal and procedural requirements for government decision making and not directly relevant in the sense that arguments about the extent of climate change and scientific evidence is very rarely put before the court in a judicial review. So there are a few fundamental issues with this type of traditional litigation being used for climate rights, and I'll go through a few of those. So first is standing to sue, which I think Piers touched on. So to bring a case before the Supreme Court in judicial review, you must show that you have a special interest in the subject matter of the decision that's being subject to review, and that has to be different from the general public and more than merely an emotional or intellectual concern. And so I'm sure everyone can see that climate change is the kind of thing that's going to be difficult to show that you specifically have a special interest over and above the general public. But it does mean that certain groups are going to be able to establish that. The second issue is sort of the merits law distinction. So that quality of judicial review being about errors of law rather than decision maker making a decision which is unjust or not a good decision. Which obviously is the character of these decisions about climate change and greenhouse gas emissions so commonly. And the issue there is that a lot of statutory powers have inbuilt discretion, so it's quite subjective. The decision maker can kind of determine for themselves whether they think, for example, an approval should or should not be granted, and as long as they've been through the correct procedures laid out in that statute, courts are pretty unwilling to disturb those decisions made in the executive arm of government. And the reasoning behind that is that those decisions are meant to be subject to other accountability systems such as elections or political consequences. But I think we all know how effective that can be in the climate change context. So the final issue here with judicial review in the climate context is the availability and utility of what's called remedies. So those are orders from the court. In successful cases, the court can quash a decision, so they can kind of cancel a decision, but rarely do they have that sort of direct, immediate, substantive effect on climate policy or greenhouse gas emissions, better climate outcomes. And then even if grounds are made out, courts will have a discretion about what orders to grant, and they may decide not to grant a remedy at all if the circumstances aren't there. So I'll just take us through a little case study, which is about the Burrup Hub, which was mentioned earlier, and the Section 45C decision. So that's the Burrup Hub. I'm sure a lot of people have heard about it. It includes gas fields that are offshore in the ocean and processing facilities that are onshore. Some of them are built, some of them are not built. This case is about the onshore facilities, which are built and operating, and the proposals to expand those to gas fields other than they were originally intended to cover. So here's an example of one of those decisions made under Section 45C. Nice little strike out there on the particular gas fields. So that proposal changes from being a proposal to develop the Pluto gas field to a proposal to develop gas fields, any gas you can find. Similar decision there made for the Karratha gas plant, which is that other onshore facility. But I won't go too much into the detail of these decisions. That's the decision that's the power that they're made under. And this is the bar to exercising the power. So a decision maker is not able to approve changes to a proposal if the decision maker considers that change might have a significant detrimental effect on the environment that is additional to or different from the effect of the original proposal. So that's a long, wordy subsection of law that a lot of people are, first of all, not going to know is there, and second of all, are not going to know how that applies to a decision, especially if it's not very widely published, not subject to consultation, all those sorts of things. But without getting into the intricacies of this too much, there is some judicial review potential in the decisions that were made under this section. So there's been a previous case dealing with this section, and in that case, the judge very helpfully set out the questions that a decision maker needs to run through in order to decide whether they do have the power to make a certain decision. So they have to ask, for example, about the impacts of the original proposal rather than the impacts that might have been in the assessment of the original proposal. So those Pluto and Karratha gas plant proposals are years and years old, decades. And in this 45C decision, essentially those assessments were relied upon to make this comparison rather than the effects of the proposal as it has been implemented in fact to date. That all sounds quite legalistic, and that's because it definitely is. So that's fine. EDO will take those on, and Conservation Council. So this JR ground is kind of one of those legal procedural steps along the way. So we have to allege that the decision maker asked themselves the wrong questions and didn't know if they had the power to do this thing, or that they didn't have the power to do this thing. So going back to the issue, so this is a case that is before the Supreme Court, so it has faced and to a certain extent overcome some of those issues. So in terms of standing, the Conservation Council has brought challenges to environmental approvals before, so the O'Leary decision is an example of that. And they're standing on the basis of being an organisation with an objective in their constitution for environmental protection has kind of made standing not so much an issue, although there's a lot of other factors that go into that I won't get into. But so far standing has been okay for some of these decisions. The next is the merits law distinction. So in this case, we can't get before the court and argue that greenhouse gas emissions will be significant and that they should be assessed properly. We have to argue that the process followed by the decision maker in that section 45C decision didn't ask the right question. So it was not the process required to be followed, basically arguing about the precise wording of that provision and certain documents surrounding the decision and proper definitions of words in that section, like original proposal or effects. And so the other issue about remedies will also affect how useful this case can be from a climate rights perspective. So firstly, the remedy that's sought in this case is only quashing the decision. So it's not directing Woodside or the government to conduct a full EIA or fix up their climate policy or consider greenhouse gas emissions and climate change. And as I was saying before, if the court does find in our favour that there has been a legal error, it can still decide to leave that decision in place on the basis of, for example, an injustice to a third party such as Woodside, who has been relying in such good faith on their decision. We'll see how that goes. So here's a little just example of what I mean about the utility of this kind of traditional litigation in climate rights. This is kind of the practical relevance of the case. So it's to the LNG projects themselves. And so it can be seen as climate litigation. But we also have to bear in mind that judicial review is really about legal errors in government decision-making and can be painfully technical in determining about these correct tests and procedures, rather than speaking about the issues that really do matter to the client and to the public interest. So hopefully Sarah will come back and tell us about those kind of issues a little bit more.
Thank you, Ruby, for informing us about the really important area of law here in WA that we need to keep using to defend our climate rights. Moving on to some more novel and innovative avenues that haven't been fully explored here in WA. Firstly, starting off with corporations and consumer law opportunities. You might have heard about some cases that have been brought here in WA against, for example, the Commonwealth Bank, brought by shareholders about inadequate disclosure of climate risks in an annual report. I'll talk about that in a bit more detail in a bit. There's also been a lot of discussion about the responsibility of companies to disclose climate risks, even though it is not legally required here in Australia, unlike other jurisdictions where it is. So ASIC ended up launching an investigation into the disclosure of climate risks by companies after it conducted a report where it found that the disclosure of climate risks by Australian companies was really poor. So there's a few cases that fall under the corporations and consumer law umbrella. Firstly, there's the failure to adequately disclose climate risks. So as I mentioned, while companies are not required to disclose climate risks here in Australia, there have been various developments that have confirmed that companies should disclose climate risks, especially where it will have a material impact on its operations or will result in some kind of harm to the company. So Australian regulators, including the Australian Securities and Investment Commission, have emphasised that climate change risk is a risk that needs to be disclosed. And it's also been discussed that this disclosure should be in accordance with a document that was published by the Task Force on Climate-Related Financial Disclosures. This is an international body that has published a report that contains recommendations about how disclosure of climate risks can be consistent across the board. So a lot of Australian regulators are referring to that to set the standard for disclosure here in Australia. Another type of case is where a company publishes false, misleading and deceptive information relating to climate change. So this can be either in corporate documents such as annual reports or financial reports, but also more publicly in advertising campaigns. So there's been some cases brought by the ACCC here in Australia already against companies in relation to greenwashing and claims that were found to be misleading in relation to carbon neutrality and offsetting. However, these claims must be proven to be capable of leading a reasonable member of the audience into error to be actionable. So there is some obstacles that need to be overcome to establish that a statement is false, misleading, and deceptive. The final type of case under the corporations and consumer law umbrella is breach of directors' duties. This is quite early in its conception here in Australia. There haven't been any cases that have targeted it yet, but there has been a lot of developments in the legal sector with two prominent barristers establishing a memorandum of opinion on climate change and directors' duties, which warned that it is likely to be only a matter of time before we see litigation against the director who has failed to perceive, disclose, or take steps in relation to a foreseeable climate-related risk that can be demonstrated to have caused harm to a company. And this includes reputational harm. So the law is developing, and it is predicted that it is only a matter of time before a director's duties case pops up in the climate context. Moving on to some examples. So as I mentioned, there's a case that's been brought here in Australia in relation to Commonwealth Bank of Australia. This related to the Commonwealth Bank's inadequate disclosure of climate risks in its 2017 annual report. It was brought by Guy Abraham, who was a shareholder, and he argued that the Commonwealth Bank did not adequately inform investors of climate change risks in that report. And this case was actually withdrawn because the Commonwealth Bank subsequently was deemed to have adequately disclosed climate risks in its 2017 annual report. So we never saw the case go through the full court system, but it showed the potential of such a case here in Australia if a company failed to adequately disclose climate risks. A case was also brought by a superannuation trust member, McVeigh, in relation to the Retail Employees Superannuation Trust. In this case, he argued that the trust had violated the Corporations Act because it failed to provide him with adequate information relating to climate risks to enable him to make an informed judgment about the management, financial condition, and investment performance of the trust. Again, this case was settled it didn't go through the full court process because it was actually settled by the parties outside of court. However, the trust has published statements confirming that it and other investment managers are required to actively identify, consider, and manage financial risks of climate change on behalf of its members, and that includes disclosure of those risks to its members. So again, shows the potential of a case here in Australia at some point in time. Another case was brought a bit more recently by a lady called Kathleen O'Donnell, and this was actually against the Commonwealth government. So in this case, Kathleen is arguing that the Australian government has failed to disclose climate change risks. Failed to disclose climate change risks to investors in relation to government bonds, and that it has breached its duties under the Australian government legislation that applies to the Australian government by failing to adequately disclose the risks associated with those bonds. In particular, she argues that climate change and its associated risks will or are likely to have a material impact on Australia's standing as an issuer of sovereign bonds and the market value of bonds, and that the Australian government should have therefore disclosed those risks to the Australian public. That case is still ongoing, so we don't know. I don't have an update at this point in time, but I'm excited to see where it goes, because hopefully it'll be the first case here in Australia that uses corporations and consumer law opportunities in relation to climate change and climate change risks. In the US, there's also been a case that touches upon that second type of case, misleading and deceptive statements. So this was brought by the people of the state of New York against ExxonMobil Corporation. And in this case, the Attorney General of New York is arguing that Exxon committed fraud and made material misrepresentations and omissions regarding its use of proxy costs and climate risks that were capable of misleading investors. This case was dismissed in the US because there was no evidence that an investor was misled. However, this is not a requirement here in Australia. So it is yet to be seen whether such a case would be successful here in Australia without that requirement. So despite those exciting developments showing the potential for corporations and consumer law opportunities here in Australia and WA, there are some issues. Firstly, under the Corporations Act, proceedings can only be brought by beneficiaries. So this includes shareholders, investors, superannuation trust fund members, and there is no ability for third parties to enforce its provision. However, the climate rights are still there for those people that fall under the umbrella of beneficiaries. There is open standing under the Australian consumer law, which prohibits misleading and deceptive conduct in trade or commerce, and that provides potential for non-beneficiaries to bring proceedings where they can prove that a statement or conduct has been misleading or deceptive. Another exciting area of law that might have some potential here in Australia and WA is tort law. So torts are civil wrongs that cause harm to someone else. Here in Australia or WA, it is governed by both the Common Law and the Civil Liability Act, which is a piece of legislation. And there's two types of cases that might fall under this new exciting umbrella. So there's negligence, which is where a duty of care is owed by the defendant to the plaintiff, and it has been breached and caused that person to suffer harm. Nuisance is where there's been an interference with public or private rights to either property or associated rights to health, comfort, or amenity, and that interference is both substantial and unreasonable. So I included that picture here because I think the first thing that pops to people's mind when we talk about tort law is the Agenda case, which was decided in the Netherlands, where the NGO, the Agenda Foundation, brought proceedings against the Dutch government on behalf of hundreds of citizens, and it won. So it successfully argued that the Dutch government had breached a duty of care by failing to take adequate climate action. So that's really exciting, but unfortunately there are aspects of Dutch law that don't translate here in Australia that make it a bit more difficult, but still shows the potential of such a case here if we can overcome all the hurdles. So there's a few cases. So Sharma, I'm sure we've all heard about that. Sharma against the Minister for the Environment, so the federal minister. Sharma and 8 other teenagers and a nun are bringing proceedings against the Minister for Environment at the federal level. In this case, they're arguing that the minister owes a duty to them as members of the general public to avoid harm to them from climate change impacts, and that she will breach the duty if she exercises her powers under the federal legislation that protects the environment by, for example, approving new fossil fuel developments. This case is still in the courts, but shows potential for tort law here in Australia. I will note that it is in relation to a statutory duty, which does differ in some aspects to a common law duty of care. However, there's many aspects of the plaintiff's argument that translate to tort law as well. So hopefully when that case is decided, it will provide hope or at least guidance about how we can bring a tort law case here in Australia and hopefully WA. Sander is another recent case. So this, that was brought this year, the negligence claim, and it was decided this year as well. So this claim was actually brought by seaweed farmers in Indonesia, and it was in relation to damage that their seaweed farm suffered as a result of an oil spill from a well blowout in an oil field off the Australian territorial coast, so in the territorial waters of Australia, back in 2009. While the case doesn't relate to climate change impacts specifically, the federal court made a lot of key findings that again will translate well into an Australian climate tort law case. For example, it found that the oil from the well blowout caused or at least materially contributed to the quick and dramatic loss and death of seaweed. And it also found in relation to indeterminacy of the liability, which is a big issue for climate change litigation, because you don't want to open the floodgates and have everyone and anyone bring cases against companies. That's a big concern with the law, to try and limit that indeterminacy of liability. But in this case, the court found that it is not an issue where a duty involves the avoidance of physical harm rather than pure economic loss. Smith is a New Zealand case, and it is exciting because in that case, the plaintiff brought proceedings against a group of companies arguing that they were liable in public nuisance negligence and for breaching a novel duty. And the High Court, while it struck out the nuisance and negligence claims, it found that the arguments in relation to a new and novel duty that is owed by companies to the public for their greenhouse gas emissions was arguable. And so as that case proceeds, it will also provide some guidance here in Australia about establishing novel duties. So that moved me on to the issues with establishing negligence here in Australia. There's 4 kind of hurdles that need to be overcome. Firstly, we need to prove that the defendant, whoever it is, whether it be a company or the government, whoever, we need to prove that they owe a duty of care to the plaintiff, whoever that is. So there needs to be some kind of relationship between them that requires a duty of care. In climate change context, it will most likely require a novel duty to be established because it will likely fall out of the established categories of employee, employer, doctor, client. So it will require some innovation to argue that a duty of care is owed. You also need to prove that the defendant has failed to exercise a reasonable standard of care in doing whatever it did, whether it be emitting greenhouse gas emissions or failing to take adequate climate action. And that requires proof that a reasonable person in that defendant's position would have taken reasonable precautions and done more than what that person did. Thirdly, you need to prove that harm has been suffered by the plaintiff. And I'll go into a bit more detail about that both in a few slides. And finally, the hardest hurdle to overcome is you need to prove a causal link or connection between the defendant's conduct and the harm that was suffered by the plaintiff. In climate context, that's going to be very difficult to prove that, for example, a company's greenhouse gas emissions here resulted in harm that was suffered on the coast over here. Proving that connection is very difficult, but hopefully with the development in climate attribution science, it may become easier as time goes on. So the first hurdle I discussed is the duty of care. I mentioned that a novel duty will need to be established. This will require innovation, and there has been discussions about how this can be done with reference to factors and or features of relationships that you can use to cumulatively argue that a duty of care is owed. I'm now going to invite Professor Alex Gardner to come up and talk a bit more about how a duty of care might be established here in WA. So please join me in welcoming Alex.
Can I just say thank you very much to the EDO and the Conservation Council to participate in this forum tonight. It's a pleasure to see just how well the EDO is thriving after the somewhat difficult years in which I played a role as convener. So what I want to do is to, in a sense, link what Ruby and Sarah have spoken about. And I want to do that by exploring a bit about the definition of pollution, because in essence, it says in the Environmental Protection Act that it's a direct or indirect alteration of the environment to its detriment or degradation, or to the detriment or degradation of an environmental value. And environmental value is human uses of the environment or natural ecosystem values. And so a significant focus is upon the harm. And that's where I want to get to, particularly on the next slide. I want, however, to start by asking you to look at this quote from Chief Justice Martin in the Save Beeliar Wetlands case, which some of you may know of as the Row 8 case, the Row 8 highway that fortunately hasn't been built. And in handing down this decision on the 16th of December 2015, His Honour said, "Some forms of pollution might be rendered environmentally acceptable by the provisions of environmental offsets. An obvious example is a proposal which would result in the emission of carbon into the atmosphere. Such a proposal might be rendered environmentally acceptable by the imposition of a condition which requires the proponent to sequester from the atmosphere a greater amount of carbon than will be discharged if the proposal is implemented, for example, planting trees." Now, I've cited that in an article which I'm pleased to say was published today. It's authored by two of the fabulous students that I had in my class, environmental law class last year, and I sort of tagged along on the end to help them a bit. And you can see the article is called "Licensing Greenhouse Gas Emissions in Western Australia." And if you want to get more direction on finding the article, I can help you subsequently. There's the citation there, I think, is adequate. What I want to ask you is, do you think Chief Justice Martin is characterising carbon dioxide emissions, let's say a lot of carbon dioxide emissions from a project, as pollution? Yes, I think he's slightly abbreviating it, but you do make a good point. But I think that emissions typically, the problem is carbon dioxide, isn't it? Yeah. So if we move to that question then, which is the second part of the slide, are greenhouse gas emissions pollution? And of course, there are many greenhouse gas emissions, sorry, not many, some, which are not carbon dioxide. Carbon dioxide, as I understand, is about 75% of the problem. And the state government argument is no. Under both Part 4 of the Environmental Protection Act, which is the part for environmental impact assessment, which goes to the case that Ruby was talking about, and under Part 5, which goes to licensing of premises or activities, as it now is under the amendments, the state government says no, because there is no causal link, as Sarah was emphasising, no causal link between particular emissions and harm. Another way the state government, and this is really coming from the state solicitor's office, advice to state government agencies, is that merely an incremental addition to the cumulative global problem of emissions is not going to amount to pollution. Now, in my view, and Steph, can I just ask, where does Steph get to? Thank you. Did you manage to give, there's some copies of this. This is a note, which is a short version of the article, which I presented for a Public Policy Institute event. And there's a few copies here at the front that you might like to follow up. I've got a few references there, or a couple of references there I can go to. But in my view, this view is legally redundant. It's no longer a useful or appropriate analysis of the situation. And the reason is because the Paris Agreement, adopted on the 12th of December 2015, then open for signature in 2016, fully signed and into operation November 2016, sets temperature goals which set a global carbon budget. And even therefore, if something might, historically have been regarded as not measurably harmful, when you know you've got a limit, when you know you've got a budget, and Australia has a budget, although the Commonwealth government's not very upfront about it, we have committed to reducing our emissions by 26 to 28% by 2030 below 2005 levels. And they've translated that into how many emissions accumulatively that will be. So we know that the emissions we are making is eating up our carbon budget. And so when you can define the harm level, your emissions that are eating up that budget become harmful. Let me give you another example. If you go down to Kwinana, there's a problem of particulate pollution, dust basically from the factories and so on, a lot of factories. And people might say, is dust pollution? Well, a little bit probably isn't. But in the volumes that it's emitted around large industrial precincts, it is. And the state government's answer was to adopt the Kwinana airshed plan, which set limits on dust pollution, on particulate pollution. And so immediately once you define that budget, if someone was emitting large amounts of dust in Kwinana, could you point to it and say that's pollution? Yes, of course you could. So I know that's a small scale and we're talking global scales here for carbon dioxide. But to me, it's fairly clear that the redundant argument should be put away with and we should move to a new view. And in that view, the cause of the harm can be generic. You don't have to point specifically to this factory or this emitter causing that particular element of harm for that person. Even in the law of torts, asbestos fibers, people who've used asbestos owe a duty of care. And you don't have to show that it was your asbestos fiber that ultimately caused my asbestosis. It's the generic activity that led to the risk. That's what has to be dealt with through the duty of care. So if we come to the greenhouse gas emissions context, what matters is the cumulative emissions against the global and Australian and WA carbon emissions budget. After the Paris Agreement, cumulative substantial emissions are measurably harmful, increasingly so as the carbon budget diminishes. And what I suggest, therefore, is that substantial greenhouse gas emissions under the EP Act offence of pollution, so under the Environment Protection Act, there is the offence of pollution. If you've got very large emissions, such as are proposed, for example, for the projects on the Burrup Hub, then you are looking at an offence of pollution unless the emitter is specifically authorised by licence or an environmental impact assessment approval. Now, that leads me back to the law of torts. In making some appeal submissions last year against a couple of EPA recommendations for approving projects with large increases in greenhouse gas emissions, I was trying to think of a way to stop the increase in greenhouse gas emissions. I thought, I know it's the harm to agriculture. I can relate to that. I grew up on a farm. My wife and I, fortunately, had a bit of land out east of York. So I could call myself a sort of a toy farmer. I can see the harm that's occurring to agriculture. The scientific evidence is there. It's measured, the loss of economic profits from climate change in the last 30 years. So you can identify the harm. And if we increase emissions now, we are knowingly increasing the harm. And it seems to me as though the duty of care, and this argument needs a lot of development, I add, the duty of care should be that you could not knowingly increase the climate change harm by substantial increases in greenhouse gas emissions. The duty, and this is a little bit different from a common law duty, is to take positive measures. It's a positive duty of care. So historically in the law of tort, we've tended to think of negligence actions arising from someone's carelessness in an omission to act. But the law of tort also says that a careless positive act is also a breach of a duty of care, or an omission to take that positive act, right? An omission to take that positive act, that can be a breach of a duty of care. So if you know that what you're doing is harmful, that there's a risk of harm, and you fail to abate the risk, then you are breaching your duty of care. So the argument for me was, you are knowingly increasing that greenhouse gas emissions. You know that'll result in harm sometime down the track for someone. You can't measure specifically how much your emissions caused how much harm, but we know it makes it worse. You've got to offset. At least you've got to make it neutral. If you're interested in the note, it's also posted on my LinkedIn site. And thank you very much for your attention.
Thanks, Alex. I note that we are a bit over time, so I'm going to try and fly through some things at a relatively high level. Moving on to, so I identified that some other obstacles that come after proving that there's a duty of care, which is very difficult to prove, and hopefully with Alex's hard work, we can move closer to being able to establish a novel duty of care here in WA. You also need to prove that the plaintiff has suffered harm. And this may include economic loss, property damage, or personal injury. But you also need to consider whether or not the harm has been suffered or whether it will be suffered, whether or not we're being proactive and preventing future harm, or whether we're responding to harm that has already been suffered. Where you're, in any case, you need to establish that there is a particular and localized harm that is being suffered by the plaintiff. And that is difficult given that the impacts of climate change are wide range, uncertain, all pervasive. And so it may be difficult to pinpoint exactly that that particular harm has or will be suffered as a result of climate change impacts. It must also be special harm, and that means that it must be more substantial than the harm suffered by the general public. And that goes back to the indeterminacy of liability concept, where if there wasn't that requirement, anyone and everyone could bring a claim if they suffered harm as a result of climate impact. That harm must also be connected to the conduct, as I mentioned. This relates to causation also. So the defendant's conduct must have caused or materially contributed to the damage. This is hard, as I mentioned, because of the various contributors to greenhouse gas emissions over time and geographically, and also the difficulties establishing the link between those emissions and impacts. However, as Alex mentioned, there is an alternative test, the material contribution test, that may be applied, that looks at the probabilistic, So in that approach, it is not just about whether or not the defendant's conduct was the only cause of harm, which is what the cause or but-for test requires. Under that test, you can argue that a defendant's actions was a cause of the harm, and that there can be a probabilistic approach to that, where you argue that because a carbon major, for example, emitted this percentage of greenhouse gas emissions between this time period, it is liable for that portion of its contribution to the harm. This is where developments in climate attribution science will be helpful. And this is a graph that was published by the Climate Accountability Institute, which sets out some of the key emitters over time between 1965 and 2017. And you can see that it's easily quantifiable there. So that might be able to be useful in terms of proving that a defendant has materially contributed to the harm. So that's negligence. There's also another type of tort law case called nuisance. as I mentioned, this is where there's an interference that is substantial and unreasonable with rights, either private rights or public rights to property or rights to health, comfort, and life. So here in Australia, there was a case brought called Ralph Lauren 57 against the Byron Shire Council. Ralph was a property owner and he sued the Byron Shire Council for its negligence and nuisance for its failure to adequately adapt to and prepare for coastal impacts from climate change. Again, it was settled outside of court, so it was not decided, but the court did confirm that those arguments could be heard in the court if they were raised again. There's also a lot of cases in the US that are being brought by local government bodies such as the cities of Imperial Beach, New York and Oakland against carbon majors such as BP, Chevron and ExxonMobil. And they're arguing that those companies are liable in public nuisance because of their actions in producing substantial greenhouse gas emissions and promoting and producing fossil fuel products. They're arguing that they have, through those actions, caused or contributed to the public nuisance of climate change impacts, in particular sea level rise and resulting damage that they have suffered to cities because of that. So they are seeking compensation from those companies for the amount of money that they've expended in responding to and adapting to those impacts. Here in Australia, there's a few obstacles to proving that a defendant has contributed to a nuisance. First of all, standing. So where you choose to go down the path of private nuisance, the person bringing the case needs to have private property rights in the land that is impacted by the interference. So that will mean the owner or occupier of the land, for example. Public nuisance is broader, however, and it's normally brought by the Attorney General on behalf of the public, but it can be brought by a member of the public, but they need to prove that they have suffered special loss or damage that is more than what is suffered by the general public. We also need to prove that there's been an interference with the exercise or enjoyment of those public and private rights to property or right to life, health, or comfort. And that will require us to prove that the defendant's conduct has caused an interference. So that might sound straightforward, but if you're targeting greenhouse gas emissions as the thing that causes the interference, there's a case in Australia that said that this won't be possible because greenhouse gas emissions are colourless, odourless and inert. So that shows, the difficulties with proving that greenhouse gas emissions cause an actionable interference with property or associated rights. However, the cases in the US brought by those local governments have instead characterised the nuisance as climate change impacts, so such as sea level rise. So they're overcoming that hurdle of proving that greenhouse gas emissions themselves caused the interference, instead characterising them as the climate change impact. So there may be potential to adopt that approach here in Australia. Finally, you need to prove that the interference was substantial and unreasonable, which requires many factors to be addressed. But if the nuisance is characterised as climate impacts, it should be relatively straightforward to prove that those impacts are frequent, ongoing, and severe. So finally, you need to prove that the defendant has caused or contributed to the nuisance of climate change impacts. And that goes to similar issues with the causation element of nuisance. But perhaps those developments in climate attribution science might help us to prove that they at the very least contributed to the nuisance. So I know that we've gone through a lot of information today and a lot of legal terms that might have made you zone out, but hopefully coming back to the reason for this event, what are your climate rights? So after all of that discussion, these are some of our ideas about what your climate right might be. So are you someone who has been affected by a legal error in decision-making that relates to climate change, and you think you meet the special interest test, which is obviously quite burdensome, but you might have the potential to bring judicial review proceedings? Are you a shareholder, investor, or superannuation member who has become aware of inadequate disclosure of climate risks? and/or misleading and deceptive statements in corporate documents such as annual reports, or you might have the potential to bring proceedings under the Corporations Act. If you're not a superannuation member, shareholder, investor, but you become aware of false and misleading statements that are made in the public domain, you may have the potential to bring proceedings under the Australian consumer law, which has that open standing that I mentioned. Finally, are you a person who has or will suffer special harm as a result of climate impacts? You might have the potential to bring proceedings in negligence or nuisance in relation to a defendant. And who is the defendant? We don't know. Who's the plaintiff? We don't know. That's why we're here tonight, to try and make steps towards bulking up the climate litigation that we have here in Australia, and hopefully encouraging more effective climate action. So thank you very much for your long-standing attention, and thank you to Ruby and Alex. I hope that you're feeling inspired, even though it was quite overwhelming.
Thanks so much to everyone on the panel. I won't take up too much time talking, but definitely learned a lot already that I heard in and out of the room. Definitely about my role also in following up on my superannuation. So that's a big one. I'll go look into what UniSuper is doing with climate change and emissions. So I guess to start with, is there anybody at all who's got a question to start with? The lucky first one. And if you've got questions as we go, I'll give this to you. As we go, thanks, Alex. Just put your hand up and I'll come round and give you the microphone for the next one. Does that sound okay? Cool. All right, so this is Vivian.
Thank you. Look, that was fascinating. My head is spinning. I could probably ask you 20 questions at the moment, more for information as much as anything. But I do have a question around a particular action that is ongoing, and that is particularly for the arts sector, where we're trying to stop or in some ways remove the social license to operate that a lot of these major fossil fuel companies have through the arts. Is there any potential? I mean, you mentioned here a person who has become aware of false, misleading and deceptive statements made in the public domain. Is there any liability for sort of arts companies who promote the brand name of a particular organisation, a fossil fuel company, who is then found to be giving misleading information? It's kind of like one step away, but I just would be interested to hear what your thoughts are.
So I interpret your question in terms of what is needed to prove that it's misleading and deceptive. Is that what?
Well, it's liability. Who has liability?
Yeah. That's a really good question. I think that it would depend on the circumstances, of course. I think generally in litigation, you go for the source of the misleading and deceptive statement. So yeah, if it was, yeah, I think it would depend. It's a complex area, but if the person that was making the statement was making a misleading and deceptive statement about someone else, it would be the person who's making the misleading and deceptive statement that would probably be liable, because they're the people that are making the statement. But it is complex in the sense of promoting someone else's statement that are themselves misleading. So I guess in some circumstances you can go for both. There can be more than one respondent, but it would really depend on the circumstances and the causal link between the statement and the misleading and deceptive nature of it. You also need to prove that a member of the audience has been misled by the statement, and that requires an analysis of the reasonable target audience member. So if they are going to know that this statement is being made about another company and isn't that statement, yeah, it would be very complex, but that analysis would be relevant also.
Just want to make a comment about this. It's a really interesting question, and I'm glad you've asked it. And I hope that our learned colleagues look into it more. And one of the ways to bring that about would be for people like yourself to approach the EDO or others to ask these sorts of legal questions. It's very hard to answer them, on the floor of a room like this because they require a lot of consideration. But under the Corporations Act, because we sought some legal advice on this a few years ago, under the Corporations Act, companies that are listed in the stock exchange have a legal requirement to disclose accurate information to their shareholders in trade and commerce. And so certain publications are regarded as in trade and commerce, the disclosures to the stock exchange, the annual reports, those kinds of things. But it's been regarded in Australia, at least, that other statements that are made by these companies, for example, media comments that are made by their CEOs, are not in trade and commerce because they're not designed or they're not intended to advise the shareholders about the company itself. And some examples of that are where the Woodside CEO says in the West Australian that if the EPA were to put in place offset requirements on their LNG projects, it would cost the Australian economy billions of dollars of investment and thousands of jobs would be lost. So that's a comment from the CEO of the company in the West Australian that makes that claim. But at the same time, they make a claim to their shareholders that their projects can withstand a carbon price of up to $80 a tonne US. So they're making these two completely different statements, which are actually completely at odds with each other. The question is there a legal liability there? And is that statement in the West Australian in trade and commerce, is it likely to affect the decision-making of their shareholders to remain invested in that company or not? And that's a question that hasn't really been put to a court, but I think I just wanted to emphasize that statements made in one way are sometimes very different, and there's different legal requirements to statements that are being made in other ways. They also, by the way, have a requirement under the Environmental Protection Act not to provide misleading statements in the information they provide to the EPA. And they provide yet different material when they make these statements to the EPA, saying that they can't afford to undertake offsets or reduce their greenhouse gas emissions and various other arguments why they can't do it. So I think that it's a really interesting question, not just in relation to the companies themselves, but as you say, in relation to third parties, other companies, other arts organisations, which may themselves be listed companies in the Australian Stock Exchange. I don't know, but some of them may be. Therefore, they may have shareholders. Therefore, their shareholders may have some special interest in relation to that company.
Thanks, Piers and Sarah. I'm going to pass on to the next question.
Thank you. Judy Fisher here from, I'd like to bring another perspective into this. And I sit elected to the top of the United Nations for the Intergovernmental Platform on Biodiversity and Ecosystem Services. So I'm sitting in that role. It's called a multidisciplinary expert panel, and we are advising all the governments. It's like a sister organisation to the IPCC, not known about here in WA, but you have an Australian out there really moving this around the globe at the moment. And I see a complete lack of knowledge of the work that we're doing here in WA. I don't see it around the rest of the world. I see it here in WA. And I'm sitting here and having to do everything by Zoom in the middle of the night at the moment because I can't travel. So what I'd like to bring into this discussion, from a lot of our assessments, which are getting so much global impact and changing legislation around the world, please start to look at this. But I think one of the key things is, I think it's, and my figure might be wrong, and I'm talking to lawyers, so if it's wrong, but it's close. There's about 40% of the changing climate that's happening around the globe is resulted from degradation of landscapes. It's not all about gas. It's not all about oil. So why are we not bringing this into these discussions? It's a huge topic. October this year, probably, we will now have a Paris type agreement for biodiversity. Why aren't we here in this biodiversity hotspot in this state doing something about hearing about this? Why we just, this is just my view from what I know internationally, While we're just continually focusing on emissions coming from gas, etc., we're missing out on a huge range of how this topic could be addressed. And I think Alex vaguely, well, not vaguely, but you sort of mentioned it when you mentioned agriculture. So there's a lot of emissions, 40%, it's in all these findings, is coming from something different to just gas, etc. So I just wanted to bring that here for your information. Get ready for it, use it, please. Let's make the most of this to really, the conversations that you're trying to have on this topic are really missing because you're not bringing or we in Western Australia are not bringing this biodiversity topic into that. We've just run a workshop with 50 experts from the IPCC, 50 experts from biodiversity, and we'll be releasing a workshop report on that in the next, probably, we're supposed to be May, but it'll probably be June. We're having to do everything remotely. That is actually going to demonstrate what I'm trying to say to you. And that's where we're actually now working with the IPCC. I'm sitting here in Western Australia as one of the people sitting at the very top of that body, advising governments around the world. So I'd love to help in whatever way I can here to bring that knowledge to here to help the arguments and discussions we're having. Because I think, I mean, certainly the legal thing might be that you're looking at particular companies, but there's a whole other gamut that we could be bringing into these discussions, especially as we've got a whole new government in place now. So thank you.
Others may wish to respond to you, Judy, but if I can just add, thank you very much for your comment and sort of in a sense a question. Why not? Why doesn't it get more attention? Look, I've been trying to get a biodiversity law course up here for more than a decade, and there's just not the opportunity to do so, and it's tragic, really. But I'd like to start by saying I don't know the figures that you're referring to. You say it's not just greenhouse gases, it's not just, in a sense, direct anthropogenic emissions that are causing the problem of climate change. Large-scale clearing of native vegetation and forests is a large source of greenhouse gas emissions, particularly carbon dioxide. And I think that's what you were trying to refer to. Is that right? It seems to me, however, that if we take your concern about the impact on biodiversity, not just from the clearing, but from actual climate change itself, then that might link back to the sort of things that Sarah was talking about, particularly a public nuisance action. If one can say, look, there is a public right to enjoy our biodiversity, people recreate in our national parks, and our national parks, and that's not only, but our national parks in places are suffering the impact of climate change. And it seems to me as though one could construct a public nuisance action alongside the duty of care action that I was mentioning and Sarah mentioned in terms of tort of negligence. But there's an interesting difference there. The duty of care negligence law is a private law duty. So you need to find private individuals or private parties who can point to the harm. The public nuisance action is, as Sarah explained, a public interest action, normally brought by the Attorney General, but also a person who can show special impact can bring it. And I think people who have a special interest in biodiversity protection in Western Australia would be appropriate plaintiffs in a public nuisance action to try and redress the causes of climate change, particularly the emissions. Interestingly, the type of negligence angle on the argument or the duty angle on the argument is probably quite similar in both causes of action.
Thanks, Judy. I might just pass on to our next question. I know there's a few in the audience and a couple more minutes left.
Can I just make a quick comment on what's being talked about as well? I just wanted to say that, yeah, thanks for raising those things. And a couple of things spring to my mind. One is that in some places, there's a new emergence of a new type of law called rights of nature. And so that is something that connects, if you like, some of the things that have been talked about with the legal system. And in some places, that's even going further, where individuals such as the traditional owner of the Fitzroy in the Kimberley is looking at first law, traditional Indigenous law, and how that can be brought into a contemporary legal context as well. So there's some really interesting work to be done there, which can actually give rights, legal rights, to parts of the natural ecosystem or natural environment, and some other countries have done that. I also did want to say, though, that this question about how much emissions is coming from different sources and the impact of land clearing, absolutely, it's a big problem globally. And globally, it may be right that 40% of emissions, I'm not sure, are from agriculture and land clearing and those sorts of things. But it really matters where you are. Here in Western Australia, agriculture is responsible for, I'll get this a bit wrong, but it's probably about 10 million tonnes per year. It's in that magnitude anyway, 10 million tonnes per year. Yeah, well, it's about 10%, yeah. That compares with the impact of greenhouse gas emissions from the LNG industry of hundreds of millions of tonnes per year. And the reason that the impact is so different is because we're exporting molecules of carbon dioxide that we take out of the ground here in WA, export to somewhere else, the gas is burned, and that's called scope 3 emissions. But that results from activities here in WA. It's our carbon that we have a responsibility for, I think, to keep in the ground. So we're talking about an industry that's orders of magnitude greater in terms of its impact. And then also the other question is, from a legal perspective, what is the responsible entity for the impact? And in the agricultural setting, it's dispersed. It's essentially like it's not really a point source emission because it's dispersed among many different small entities that overall contribute to a problem. Whereas in the gas industry, well, it's 2 or 3 major companies that are responsible for this, right? It's Woodside, it's Chevron. And so from a legal perspective, you've got the ability to hone in on or from a perspective of a decision-making by government that allows a gas project that would have more emissions than the Adani coal mine, 1.7 billion tonnes of emissions, one decision about one project that you can pin a legal argument to. So I think for those reasons, that's why the emphasis sometimes goes on these kinds of issues, but it's absolutely important to remind us that there are other dimensions to this which need to be looked at.
2 quick questions. One probably for Ruby. Section 4A of the Act sets out the 5 principles that are the objects of the Act. Have you been able to use those as a basis for questioning whether a decision maker under the Act has been in error? And I'll just ask the other one to Alex, what are you thinking about that? The problem with the definition of pollution, Alex, is that reflected in other Australian legislation as well?
Yes, thank you for the question about the objects of the Act. I really like objects of Acts. I think it makes sense to have a little bit set out about what the powers in that Act were intended to be exercised for. Unfortunately, most objects provisions in Acts are to, take into account those principles, or they just they generally sit there and given lip service in decisions. It's just copied and pasted in, and it's very hard to argue that a decision maker was required to actually fulfill those objects. It has been attempted, and it goes fairly well in things like merits review, where you might be arguing to the appeals convener that, look, the precautionary principle is there. We think that there's this threat of harm that was identified. Therefore, how about these conditions, which are more of an adaptive management style? But unfortunately for judicial review, it's really hard to get them in. But I am aware of one case at the moment that does have it as a ground of judicial review. And that should be heard at some point this year, I would presume. So we'll see if they can get that one up. It'd be amazing if they can get an objects case up, because it would be so useful. Intergenerational equity is probably one that a lot of people think about to do with climate change. So we'll see if we can get those EP Act objects working.
Can I link Ruby's answer to your question about pollution? Again, on state solicitors' advice, the department and the EPA do not treat greenhouse gas emissions as pollution. Therefore, if you look at the greenhouse gas emissions guideline for environmental impact assessment, they don't mention the principles of section 4A in relation to their assessment of greenhouse gases. They mention only one, the fifth principle, which is waste minimisation, because they treat these as just emissions that should be minimised to the extent that's reasonably practicable. Whereas if one can show that a correct application of the definition of pollution includes substantial greenhouse gas emissions, then you could go further and say the EPA should be treating the substantial emissions as pollution and therefore applying those or considering those objects principles that relate to pollution, such as the polluter pays principle. So that I think would be the next step. You asked to what extent is this definition of pollution an issue in other jurisdictions? I can't actually answer the question in any detail. I understand that there's a case being run by the EDO in New South Wales at the moment, arguing that the New South Wales Environmental Protection Agency should be regulating greenhouse gas emissions, which they have not done. There was a case, Macquarie Generation, about a bit over a decade ago, where there was an attempt to say it should be licensed, and the New South Wales Court of Appeal discarded that argument. In Victoria, however, there is express provision to license greenhouse gas emissions. And so you don't have to have the argument. I think Sarah and Ruby have looked at this. You don't have to have the argument. Are they necessarily classified as pollution?
Thanks, Alex and Ruby. And I think we've got quite one more question because we've still got a few more people we'd like to hear from tonight. We'll take it from the Zoom. I know there was one question. So is Lee's going to read it out?
Yes, I think maybe Sarah can answer this one, but it says from Jen, could the smoke from prescription burns fit the nuisance category, causing harm to life, health, or comfort?
Can you repeat that one more time?
Could the smoke from prescription burns fit the nuisance category, causing harm to life, health, or comfort?
I mean, great question. I don't know if I can answer that right now, but there is a lot of factors involved in that analysis. So you would need to consider whether that interference caused by the pollution was unreasonable and substantial. That will require you to consider the normal locality of the area in which you are, the frequency of the interference, the duration, the severity. There's a lot of factors, but I think it does have potential. There are a lot of cases that argue nuisance for pollutions similar to that. So it's a more established area as opposed to greenhouse gas emissions, which are a bit more speculative. But yeah, definitely potential, but can't answer that on the spot. But Alex might have more guidance.
There was a case about this. I haven't got the exact name, but Southern Properties or something like that. It was a winery down near Pemberton that suffered harm to its grapes from a prescribed burn. And Tim's sort of shaking his head like he knows it, so he may be able to add more to this. But the winery complained that the prescribed burn was negligent in being conducted at the time it did and causing the smoke to blow over and damage the grapes. And the court's response was, there's a statutory power here to conduct prescribed burns or controlled burns, and that overrode the duty of care. So you do have to look at is the argument of a duty of care, or in public nuisance, is a common law argument displaced by the statutory authority to conduct the activity. This argument was put back to me in my submissions, and anyone who's interested, I can inform you a bit more about how it went.
All right. Well, thanks everybody. Thank you, Alex, for that, and Sarah. Sorry to cut all the questions short, but we do have just some final speakers we'd like to hear from. So if you could join me in thanking our wonderful panel, very intelligent, smart panel. Thanks so much. Just give one sheet.
I'll just say a couple of words in conclusion, which is very brief, and to say that we hope the EDO will be swamped with inquiries and potential clients that will come to them. They obviously haven't got enough resources at present to meet all those demands, but we do note that there are people out there who are willing to donate to these kinds of cases, and thanks to those who've already donated to support the case that we're bringing before the Supreme Court, the judicial review in relation to the Burrup Hub approvals and those LNG projects. So thanks to those who have donated to that, and for those who haven't, please go onto our website and make a donation. But yeah, I think it's been great to have that information presented to us from the EDO in that concise way. It's covered a very broad range of different legal areas of legal practice and thought. And I think that's been done in a very concise way by Sarah and the other lawyers from the EDO. So if we can put our hands together to thank them. And for those online, yeah, thanks for joining us. And we've just, I think, got a few or a last presentation or something to be made, which Steph will let us know about before we can go home safely. So thanks very much for being with us.
All right, so I'm just going to welcome up to the stage now. We've got two UWA students here, which we're very fortunate to have along, who are just going to be summarising really for us another angle of what you can do lawfully and legally as a citizen, and giving their perspectives from some really interesting work they've been doing here with UWA. So we've got Mayor Taylor Treno and Samuel Keller, who are from Fossil Free UWA and the UWA Students for Environmental Action. So come on up and we'll hear from them.
Hey everyone, we'll try not to take up too much of your time. So yeah, just quick introductions. I'm Maya, I'm from Fossil Free UWA, which falls under the Environment Department of the Student Guild here. And this is Sammy.
I'm Sam, yeah, I'm from Students for Environmental Action and we're a student club.
And I guess takeaways from tonight for me is that we do have legal rights to a safe climate, well and truly. And I think that there's a lot of action that we as individuals can partake in order to pursue a safe climate. And that kind of ties into what we've been doing through Fossil Free and S3A this year, which is sort of moving away the student climate action from what it typically is seen as in protests and sort of big actions like that, which are extremely important and definitely a part of the picture towards making the relevant changes that need to happen. But we have sort of wanted to explore different methods of direct action on climate change.
Yeah, and we're exploring some of those other options through meeting with staff members and building relationships and working constructively with the people who have the power to make decisions. And by addressing issues that are specific to UWA, we think this has more potential for tangible change rather than just getting up at a protest and protesting the whole situation of climate change in general.
Yeah, and sort of through the discussion and discourse that we've been trying to engage students and staff in, we're sort of starting to build a bit of a climate action community at UWA, or at least a stronger community. And I think we really, we've only really just started, but looking into the future, we really want to amplify students' voices at UWA and sort of empower students to go to their faculty heads, go to their MPs and have direct discussions with people, have conversations with the people who have the power to actually get change happening. So I don't know how many of you are students,
But if you are a student, or even if you're not, you can say hello to us afterwards. We're pretty friendly. Or you can check us out on Facebook. So Fossil Free UWA or UWA Students for Environmental Action. Great. Thank you very much.
thank you.
Wonderful. Thanks so much, both of you. And thanks to all of you for coming along. It's been amazing to have such a big crowd just after all these COVID restrictions have been lifted. And again, thank you so much to our wonderful speakers tonight for putting in your time and energy to explaining very complex but important area. So thank you so much. I think Alex has a final thing to say. Oh, and thank you to the Conservation Council staff, of course, and to Clean State campaign, who've put a lot of time and energy into putting tonight together. So thanks very much. We do have another Environment Matters event coming up in July. So save the date. It's the 14th of July and more information will be coming out on that soon. Would also love to plug, if you're not following Conservation Council on Facebook or Instagram, you definitely should be. And also if you'd like to sign up to our mailing list, we've got some sign up sheets outside as well. So if you haven't bought a t-shirt yet, grab a t-shirt or take some of the free stuff to take away and read later. We've just released our bold vision and it would be great if you could read it. So thanks very much. You can hang around for a bit longer if you want, but we get kicked out at exactly 9 o'clock. So have a good evening. Thank you.